This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight it's Ask Us Anything night. We open the phone lines up to any kind of legal question. So call in if you've been in a car accident and you've got questions. You're dealing with an insurance company, you've got questions. You're thinking about divorce or you've got child support you can't pay. Call in. The 31 Law Call number 256-536-0077. You can call in, but you can also text in your question. You text to that exact same number and we will have some of those tonight. You can also email your questions. You send the emails to lawcall@waaytv.com and you can send them anytime, any day of the week, and we pull some out for shows that are questions that are on point. We will have some of your email questions tonight. Will League is here from Timberlake, League and Brooks. Good to have you here.
Sharon, how are you?
Doing very well. Had great Halloween, lots of things going on, busy neighborhoods.
That's right.
I hope everybody got home safe and they didn't have candy problems or injuries.
The rain helped out the parents a little bit, but it's sad for the trick-or-treaters. Hey, we love the email and text questions. Daylight saving times, be brave. Give us a call. Whatever question you got, we're happy to try and answer it. Everybody's asleep anyway. It's daylight saving times. Everybody's probably been asleep, so nobody here but us.
The time change is always tough.
That's right.
So call in, text in. We've got our video for tonight. The You Make the Law Call video that we pull. So this is an instance outside a downtown bar, and you got a little scuffle that's starting to happen outside, and it's hard to tell exactly who is working for the bar. I don't think we see a security person come out for a little while. We watched to get out of hand.
We watched it just a second, so the guy in the hat and those other two guys are kind of, that's not good. That's not good.
So I see this guy coming out in black, and I think that he's the security maybe that's working there and trying to stop things. Yeah. So nobody gets really hurt in this one. But if this progressed, or you are part of a fight that breaks out at something like this, when does the bar or restaurant become liable for the injuries? Or what if these folks have been drinking at the bar and they've had too much?
It looks to me, I didn't see what happened on the inside the bar, but it looks like to me the aggressors were the two guys in the white shirts.
Yeah,
right?
Like.
So several different factors. First off, absent anything else in the bar or some type of self-defense, the law in Alabama is you can use reasonable force to protect yourself from like-kind force and even deadly force if you fear for serious bodily injury or death. You can also protect third persons if you feel like they are in imminent danger. Depending on the level of force, will determine whether or not you're guilty of murder or even assault, depending on if you can reasonably infer that you are using reasonable force to protect yourself or others from a reasonable threat. In this particular case, the two guys in white clearly assaulted the other guy with the hat.
Yeah.
So criminal charges, assault, battery. District attorney will pursue those charges. That's on the criminal side. On the civil side, they could be liable for, the same thing on the civil side for assault, battery, paying medical bills, compensatory damages, things of that nature. Now that's between them two. Now under dram shop law, you asked Sharon what if these folks are drinking.
If they've been drinking too much.
Under Alabama law, if you are served, contrary to the provisions of law, the law says you cannot serve anyone who's visibly intoxicated. So let's say the bar serves those two guys in white shirts, they're so drunk that they leave the bar and hurt someone in their vehicle. Under dram shop law, they could be liable for serving someone contrary to the provisions of law. In this particular case, that's a direct assault, intentional conduct. So I'm not certain the bar would be liable for over-serving and then there was an intentional conduct such as, a crime. It's going to be, you have to show that it was reasonably expected, from the standpoint of the particular bar. You asked about security. Now, it happened on the sidewalk and in the street.
Right.
That's outside the security, their purview.
Right.
You have a duty to protect your patrons against reasonable and known threats or something that you should have been aware of. Depending on what happened inside the bar, if there were threats and they failed to act, and let's say this happened the day before, and there's a comment and they failed to provide enough security. We've had several cases to where the security is overzealous and hurt someone.
Yes.
We've had several of those.
We've seen those.
A lot of guys sign up for security or are ready for action, unfortunately, and a lot of them are really good. It just depends. But in this particular case, we don't know what happened. If there wasn't enough staff, that could be an issue for the bar. It seems like it spilled outside. And, again, they have to be reasonably, aware that something like criminal conduct could flourish from their either omission or, lack of security or over-serving. So sometimes it's a tough jump. But again, they certainly have, the guy in the hat certainly has a claim against the other two guys who assaulted him.
We've got callers waiting. We've got Remy on the line with a question from Rogersville. Hi, Remy. Thanks for calling. What's your question tonight?
Hi, Sharon. Hi, Will.
Hey, Remy, how are you?
Well, I'd spoken to you before about this. I have a judgment that it was in Texas, and it was for, at that time, it was like $30,000, and the judge set the interest at 6 or 6.5%. And I'd called and asked you about it, and you said on the show, and you said something about that you ought to retire the judgment or something to the effect, I guess, to make sure that it was locked in. The reason I'm asking is at the time of the judgment, the person they rented their cars or leased their cars. They didn't own, they had just one primary residence. So there was nothing for us to claim. But it's been time since that, and I'd like to reopen that to see if the person has accumulated anything that could be seized.
How long has it been, Remy?
The judgment, I believe, was in 2016.
Okay.
I think it was.
All right, now it's in Texas. You got a judgment against an individual, correct?
Yes,
Okay. All right, so anytime, if you have that judgment, once the case is, relatively over and there has been a final judgment in the case, then you can file what's called post-judgment discovery, post-judgment interrogatories and requests for production. Where do you live? What's your bank account? How much do you have on your mortgage? How much equity do you have in your home? How many vehicles do you have? What bank account is this? So then you can get into the finances of a defendant. For example, before there's a final judgment, let's say it's from a motor vehicle wreck, we're not allowed to get into discovery into the personal assets of the defendant. And in Alabama, you can't find out unless you file a lawsuit how much insurance someone has. And that's different than other states as well. So in this case, Remy, let's say it happened in 2016. In Alabama, you've got 10 years, and that keeps it open in probate court. So you file that judgment in probate court so that you can then go back and execute on that judgment. You're within 10 years. I'm not certain in Texas, but in Alabama, you'd still be within your rights. But again, you can refile that every 10 years and re-up that judgment. So file some discovery on the defendant to find out what he or she has in the way of paying that judgment. Sometimes there can be bankrupt issues, like that assault case we just saw. You wouldn't be able to claim bankruptcy for an intentional tort. Let's say, for example, you're drunk, you run through some folks and you hurt people. That's reckless conduct. So those punitive damages may not be a vehicle to where you can claim bankruptcy.
Okay.
But if it's negligence, for example, you might be able to claim bankruptcy and keep some of your assets, and protected through the bankruptcy court. So file your discovery, follow up with that. You may need an attorney to do that in Texas. You need a Texas licensed attorney, and you never know what you're going to find. Request for production. If they do not file, if they do not answer, then they can be in contempt of court, and you have other remedies as well. So that's one way to go about finding assets. And Sharon, you don't get into that before the lawsuit. Once you get a judgment, then you can.
Yeah.
Most time, the defendant has insurance, and the insurance pays that. Now, in Alabama, the jury's not allowed to know that.
They have insurance.
That's correct. So if I hit you, it's Sharon versus Will in court, the jury's not allowed to know that I have ABC insurance, and they think I'm writing the check. And so it matters, sadly, who hits you.
Yeah.
If you have the little lady on the way home from Sunday school and she made a mistake, but someone's still dead, sadly, the case is worth less because the jury does not know there's insurance.
And they don't want to come back against grandma.
That's right. And so, and that's by design, and that came right out of the legislature and came right from, frankly, the big insurance lobbyists, and they're winning the state right now.
Remy,
sadly.
if you're able to collect your $30,000, call us back and let us know. We're very interested. We've got Judy on the line with a question from Hazel Green. Hi, Judy. Thanks for calling. What's your question tonight?
Yes. Is the police officer allowed to keep your evidence that you can take to small claims court?
What kind of evidence is this, like a car accident, or what is it, Judy?
No, it's the lady that sent me a check, not for all the amount, but just for a small amount, and the police officer got it. And now he won't give it back to me because, and I can take it to small claims court, but he won't give me my evidence back.
Evidence back.
And your
That's
evidence is your check?
Yes.
And that shows that it's a partial, she only made a partial payment?
Yes.
Interesting. I think they'd be able to make a photocopy and still keep that into evidence to where you could still redeem that check for at least partial payment. They can, sometimes they can. Let's say you were moving a bunch of cocaine and they confiscated those drugs or illegal drugs. Turns out they didn't reach your rights. There was a Fourth Amendment federal, government violation. You're innocent. You don't get your cocaine back, so they can keep that, Sharon.
Okay. Good to know.
They can
okay.
keep that. If you got a gun, you use that gun, you're convicted. You don't get that gun back.
Right.
You're not guilty. You can get that evidence back. So if they confiscate things, sometimes you're allowed to get them back, sometimes you're not. In this case, it sounds like she should be able to get her check back, execute it, have partial payment, and then move on. But again, like in cases that we're involved with, oftentimes we'll submit things into evidence. Case is over, the court porter will call us, hey, do you want this evidence? I've got it here for whether there's appeal or whatnot. So it's a big job maintaining, keeping those, all the evidence and making sure that it's there in case either side needs it. But there's a time limit on that.
Okay. We're going to take a break. We're going to be right back answering more of your questions. We've got a lot of text questions in and calling your questions. It's Ask Us Anything night. Stay with us.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi. And hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. Tonight it's Ask Us Anything night, so call in your questions or text in your questions to 256-536-0077. Will League is here from Timberlake, League & Brooks. They are personal injury attorneys, so everything from car accidents to medical malpractice to Burger King and McDonald's. So McDonald's has been in the news in the past couple of weeks about the illnesses.
Right.
Whether it's the onions or whatever it is. Is that a class action suit?
So class action, we every now and then we'll work on class action cases. Right now we're working on several. But basically when you've got so many people that have a claim against the same defendant, similar facts, similar damages, similar injuries, under judicial economy, it's usually to try all of those hundreds, and thousands sometimes of cases. The court will say, you know what, we're going to bind these cases together for discovery purposes, and let's see if we can get a resolution for everyone at once. And that's basically a class action. When you got so many people with similar issues that it's in the judicial economy, it's best to try those together. For example, the McDonald's, I think, Quarter Pounder has been in the news recently. We've had a call. Interested to hear, if anybody's had any experience with the Quarter Pounder, contracting a foodborne illness, E. coli. And that's the claim that there was a plant out of Colorado sending out this product. And, is it a class action? Product liability? All it's got a little bit of everything.
Interesting.
So product liability, if a designer, manufacturer, puts their product in the stream of commerce and they knew or should have known that it was a danger, and you're using that particular product for its intended use, there may be a product liability claim. Okay? Now, you have to be you can't use your weed eater to trim your mustache. It has to be using that particular, item for its intended purpose. And this, if you eat the hamburger, you get sick. If you can prove that, there's so many people around the country that have had those issues. It may be one of those class action situations.
It's not enough that you ate a hamburger from that same restaurant. If you didn't get sick, right? You have to have bbeen damaged. And to have a case, you have to have been hurt.
Right. On negligence, need duty, breach, causation, and damages.
Okay.
So, if you eat the hamburger, nothing happens, great. You didn't suffer any damage, you don't have a claim.
Okay.
And so that's, it's like baking a cake. You have to have all the ingredients to maintain an action and meet every specific element of that claim in a court of law and being able to prove that. And then damage is one of those. And I have people come in sometimes that said, look, this almost happened, and thank goodness it didn't.
Do I have a lawsuit?
Right, and no, you did not. And that's a good thing, because you didn't incur any damage.
Yeah.
Or somebody hits you and they have a duty. You're playing football. Sometimes you agree, maybe you sign a waiver. These folks who go out on weekends and race cars, and they're in a car wreck on the track. Well, that's maybe rubbing some racing, I guess we've heard that somewhere. But unless it's intentional conduct. Now, we've seen, coming out of Huntsville Speedway, unfortunately, we've seen a lot of craziness. If anybody races out of Huntsville Speedway, you've been out there, you know exactly what I'm talking about. But sometimes there's intentional conduct that does give rise to not only criminal, but civil liability as well.
We've got Renee on the line with a question from Madison. Hi, Renee. Thanks for calling in. What's your question tonight?
Hi, good evening.
Good evening.
I had a question about HOAs.
Okay.
So in my neighborhood, there is an HOA in place that was established by the developer maybe 15 years ago when the neighborhood was built. And so that developer is long since gone, and we are fully, all the lots are full now. But the current board has become toxic, and many of the residents are displeased with some of the things. And in addition, the covenants and things are they're outdated now for a fully populated neighborhood. So one of the things that has come up is, can we dissolve that board? And if so, how would we go about being able to do that? Because one of the board members has gone out and sought legal counsel, but we have been informed that legal counsel serves at the pleasure of the board and is not there for us, the residents. Yeah. So would we have to go and seek legal counsel? Would the residents have to go and get another lawyer?
Good question.
Let me ask you this, Renee. What are some of the things they're either enforcing or not enforcing that a lot of the residents disagree with?
Any crazy ones? Really crazy ones?
Well, I know one of the things that recently came up was a political sign.
Yeah.
And, it's nothing egregious, but there is a sign, and the board member doesn't care for it. Most of the residents are okay. And then, of course, you have other signs, for school kids and, things like that.
Yeah.
But I think the difference in the political opinion, that kind of sparked a lot of contention. But, I think the original covenants or bylaws or whatever prohibit signs, period. So it was brought up, well, the way that the original ones are written, you're in violation just by having your security sign in your yard. And we're like, okay. So, things like that need to be...
Renee, it raises a lot of questions, because let's just take that one, for example. The developer, develops this property, owns this property, can do, as long as it doesn't violate the law, implement restrictive covenants, can't grow trees, on your property line, all kinds of things. If there was some type of covenant that you couldn't put political signs in the yard, I'm not certain that would hold water, because then you're talking about a constitutional right of free speech. Now remember, when you buy a lot or buy a home in that community, you are agreeing to all of those restrictive covenants and bylaws of the HOA. And it seems like Sharon will get calls, and it seems like every community has a Mrs. Kravitz.
Yeah. Somebody's in everybody's business.
Right.
Yeah.
And so it gets contentious. So Renee, you and the other homeowners will have to get legal counsel to challenge that. And the best way to do it is to start getting your folks elected on the board and making legal or permissive changes to those bylaws.
Yeah.
And just because the head honcho doesn't like this sign or that sign, that's not enough to get around free speech. However, if everyone who moved in the neighborhood said, hey, we agree we're not going to have signs, we agree we're not going to grow sycamore trees, whatever it calls for or doesn't call for, but you've agreed to that, and so you'll probably need a majority to make changes to those bylaws in accordance with how they're written up.
We've got John on the line with a question from Decatur. Hi, John. Thanks for calling. What's your question tonight?
Yes.
Yeah. Hi, John.
Turn your TV
Thanks for
down,
calling.
John.
John, turn your TV down and just listen through your phone because there's a little delay there. What's your question tonight?
Yes, I had got booked into the Gator, Morgan County Jail.
Okay.
And I had gave them a $100 bill and my driving license, and they have not gave me my driving license. They keep telling me that to come see these people, and they have not responded back to me. They got my phone number. They still haven't given me my driving license, my $100.
Gotcha.
So when they turned you loose that night, they didn't provide you with your belongings, obviously?
They didn't. They gave me the rest of my stuff, but they didn't give me my $100 or my driving license.
Did they say it's lost, or did they give you a reason?
They don't got no reason. I mean, they got camera. I'm right in front of the camera, handing them, my stuff.
Right.
But they didn't let me sign off on it.
So they acknowledged that they had it. They acknowledged when they took that log of what they were taking from you, they wrote down $100 and license. And so you've got proof that they took it.
Yes, and they tell me go see these people upstairs. I go upstairs to see them. They send me back, and they say they're going to look over it and over the cameras, and then they're going to get back to me, what they never have.
Well, okay. All right. So, well, John, you've done the right thing. When you're turned loose, hey, let me have my stuff. You went back up, talked to folks upstairs. Sounds like you're getting the runaround. They may not just have it. Now, whether you're guilty, not guilty of underlying crime, they can't have your stuff unless that money was directly used in some type of crime, okay? Let's assume it was not, and you're entitled to that. So, the theft is a criminal action, but under civil, it's conversion, okay? So you could sue them for the value of that $100, which is $100, and your license, which is basically going to get a new license. So is it enough for a small claims action? Maybe. You have a right to your stuff, your belongings. They wrongfully withheld them from you. That's not only criminal, but it's civil conversion. Hopefully you can go and get it worked out, but you can file a small claims action against the city, and get the like kind value.
I'm trying to think who else to complain to. We're going to take a break. We'll be right back answering more of your questions. It's Ask Us Anything Now. If you didn't get your questions answered tonight, here's how to get in touch with Will League with Timberlake, League & Brooks in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com, and if you like them on Facebook, you can learn more about the law that way.
And a family law attorney, Sharon Doviet, 539-7337, SharonFamilyLaw.com. Had
somebody texting in about equal airtime and that Harris was on Saturday Night Live. Is that a violation?
Equal time. If you're stationed, you got to provide equal time, or at least offer equal time to each candidate. And if there is a commercial, you have to let the consumers know who's paying for the commercial, who's presenting that information to you. And unfortunately, with the we got an election coming up. Super PACs. That's been in the news lately. Unfortunately, with super PACs, billionaires and big corporations can control the market and donate as much money as they want, and the people don't know who it's coming from. So it's not as transparent as we would like the law to be.
Bet next week we'll be talking about elections. Thanks for all your calls and questions. We'll see you next week.